Good morning, comrades. Honorable
morning.
members, oh, excuse me for saying comrades. I wanted to say morning, honorable members.
Morning, Chair.
Morning,
Morning, Chair.
morning, and welcome back after quite a long time. I can see that we are 17 in the platform, and I look at the time, it's 1 minute past 9, and our meeting is scheduled for 9 o'clock. So can I be allowed to start the meeting, honorable members?
Yes, please, Chair.
Okay, thank you very much. I know for a fact today it's going to be sort of a hurry because we have to go to Parliament. So we mustn't waste any moment. Otherwise, let's first bow our heads where we are and thank God that we have managed. Those that are able and those that are not can just sit down or whatever do. Thank you. Thank you very much, honorable members. The meeting is officially opened. And let me apologize for my voice. I think I'm starting to have flu because of these different climates and temperatures around. So I don't feel comfortable to be in the video. And also this network is messing up with us. Otherwise, I wish to welcome everybody in the meeting. And I've said already that let us not waste any minutes so that we can be able to catch the buses, those that are able to catch the buses at 12:30. So can I check with Lindy? Well, Lindy, where are we all in the meeting?
Yes, Chair. So far, I have 7 members who are in attendance and 2 apologies. So about 9 members have been recorded. And then we have the standing apology for member Abrahams. There's only 1 member short. But you can proceed.
Morning, Chair. I'm in the meeting.
Yes, ma'am. I've also recorded your name, Member Aris. I saw you with your phone.
Okay, before we start the meeting, let's say happy birthday to Honorable Kate Bilangolo and say we wish her all the best and may her learn to her yes, and happy Valentine to all members. I have forgotten about this thing of Valentine. I wasn't sure whether it's really a Valentine. Anyway, this is the month of love. Let's love one another. Let's love our families. Let's love our boyfriends. Let's love our husbands. Let's love our colleagues. I know
I didn't have boyfriend.
Yeah, it's fine, Tina. I'm a boyfriend. Wait for us, those that are having those things. The husbands, you can go and fetch your husband from Tanzania. Meche is still alive. Otherwise, love everyone, love your kids, love your colleagues. That is the best thing to do because most of the time you are spending those times with your colleagues at work. So if you don't have one boyfriend, just look around and get one. Otherwise, happy birthday, happy Valentine. I'm so happy that mine was 2 days ago, my birthday. So happy to myself, happy belated. Thank you very much. The meeting is officially opened, as I have said. And Lindy, will you please flight the agenda and then confirm the attendance as you have said? You name them, those that are present, or you name those that are absent, and then all of others are present, I know. Thank you very much, honorable members.
Thank you very much, Chair. I don't know whether before I proceed, Member Masango's hand has been up for some time. I don't know whether I must start with the confirmation and the agenda or before her. Chair? Am I audible, members?
Yes, you are audible, loud and clear.
Oh, okay, Chair.
Let me check what Mama Sango wants to say.
Okay,
Thank you.
Thank you, Chair. I just wanted to, I don't know whether I preempted the taking of apologies. I need to leave the meeting, Chair, if that's okay with you, at 12:15 for another appointment, please. Thanks.
Yeah, you were just in a hurry. I was going to keep you, but at least you have done it, which I also think that by 12 the meeting must be finished, as we will all let the rush for the buses and also preparing for the debates. Thank you very much, Mama Sango. Let's give over to Lindiwe to continue. Lindy,
thank you very much. Okay, thank you very much, Chair. Today is the Valentine's Day, which is the 14th of February in 2024. Compliments of the new year members and officials in attendance. Chair, I wish to confirm the following members who are in attendance of this meeting. Member Mvana as our chairperson, Member Manganye, Member Stock, Member Peterson, Member Bilankulu, Member Masango, Member Eris, Member Mhlongo. Chair, we have our standing apology from Member Abrahams, who's on maternity leave. Chair, I have some apologies. I don't know whether must I proceed to the apologies, and then we follow the next.
Proceed, lady. Proceed, lady.
Sorry.
Who's calling me?
It is Member Marie. She didn't mention my name. I am in the meeting.
Okay. Sorry for that. Thank you. And the apologies, Lindy.
Okay, Member. Chair, thank you. Sorry, Member Bonita. You're Marie about that omission. Chair, I received a member from an apology from Member Sukers, who is unable to attend today's meeting due to prior commitments. And another apology, Chair, is from Member Fanda Merva, who will be attending the PC on Home Affairs. She is also serving that committee, so the meeting are clashing, so she'll attend Home Affairs. Chair, this is an internal committee meeting, but the department is in attendance just to listen and observe some issue that may be required from them. It's safe to say that we have in our midst the Deputy Minister is also present, and the ADGs and other officials from the department are here, Chair, although Yoli will be presenting and there is the summary of submissions, and also I'll present the committee program for the first quarter of 2024. Thank you very much, Chair.
Okay, thank you very much, Lindy, for informing us who is in the meeting. Let us acknowledge the presence of the DM and the officials that it is said that they are with us. Anyway, it is really an internal meeting, but we really appreciate them and their presence, and we are happy that they have joined us, and we wish to welcome them. And we want to congratulate the DM in terms of her programs. We saw the Tommy launch I was asking myself, I wonder what is it that is happening in that Chomi Lodge. I wish I was there and enjoy the Chomi Lodge also. But I can see that whenever she has a program, she always put it in the group, even if we are unable to attend them. But we also see that she is really moving with the programs of social development. Thank you ever so much. Now, Lindy, the next item is
the presentation from Yoli on the summaries. Chair, I've omitted to mention that I've also received an official apology from the office of the minister. She's out of the country and unable to attend today's meeting. So I just wanted to mention that for our records. Thanks very much.
okay. Thank you, Lindy. How she was in the house was yesterday. Said, okay, we wish her all the best. But now that the DM is with us, I hope that she is going also to listen our deliberations, and also if there is anything, we will hear from her. Thank you very much, Lindy. Let's go to Yoli.
We all need just to adopt the agenda first before we proceed to the content advisor. Yoli.
Okay, I'm sorry for that. I think we've got rust now. We forget the process and procedures of the meeting. Of course, the agenda has been proposed, and also, honorable members, we felt that we can't miss this day, knowing exactly that we'll be rushing for the debates and also this. But if we miss these days, it's going to impact on our agenda and program. So we said, let's have it, even if it's not gonna be long, but let's rather honor it. Thank you ever so much by understanding that we shouldn't miss our plan or our program. We should continue as such. Then, can I get someone who will adopt the agenda as proposed?
Good morning, Richard. I would like to propose the adoption of the agenda, please. Thank you.
Thank you, Mapreji. Thank you. Any seconder to that?
I second the move, Chair.
Birthday
Honorable
girl.
Bilangoni. Thank you.
Honorable birthday girl. Thank you. The agenda has been adopted and seconded. Can we then proceed to the next item?
Thank you, Chairperson, and good morning to you members. Good morning, Chair and my colleagues. And it's good that everyone were back and we are safe under God's care. Chair, may I request to keep my video off? Where I'm sitting, the lighting is not so good, so the video is not really looking good. So if by your permission, Chair, can I just keep it off? Then I'll proceed, Chairperson.
Thank you, Yoli. You can proceed. It's being known, this thing of the load shedding and the network that is poor.
Yes, Chairperson. Can you see the slides, Chair? Okay.
Yes, Yoli.
Okay, is it big? Okay, thank you, Chairperson. I'm just going to try and just rush through. The presentation is quite long, Chair. If I may just mention, I don't know if the members saw, it's about 99 slides. And I'll just try to read through them with the assumption that maybe the members have had the opportunity to go through the report, because I think Mrs. Lindy forwarded the report early this year, if not late last year. So at least the report has been out. So this is just a presentation of the report and the summaries of the submissions that we had received, Chairperson. So, Chair, maybe starting with the background, the The advert for the submissions was issued from the 7th of April to 19th of May last year. And we received 7 submissions from organizations and 2 from individuals. And they are listed as such. We had a submission from Professor Kitty. I'm not quite sure how to pronounce this surname, Chair. Please pardon me. I don't know, it's Malhebe or Malhibi. I'm not quite sure, Chair. Professor Kitty. We had a submission from Red Aid Association, Ilitala Bantu, National House of Traditional Leaders, Western Cape, COSATU, Dear South Africa, Mr. Johan Rademey. And I can just maybe mention up front here, Chair, that this submission was submitted to us or to me in PAL when we were doing provincial hearings, but I decided to include on this presentation because he indicated that he wants to come and make an oral presentation. Otherwise, there was some submissions that we received during our provincial visits that are in the other report that reports on the other presentation that reports on the provincial hearings, Chair. Then we had another submission from the Southern African Catholic Bishops Conference, Parliamentary Liaison Office, we in short is called CPLO. Starting with Professor Kitty, Professor says that the bill enhances the realizations of other persons' constitutional rights, particularly as far as the protection of other persons.
Recording in progress.
She also welcomes the alignment of the definition of older person with the definition in the Social Assistance Act of 2004. However, she feels that there's a lack of clarity regarding, now this is a spelling issue here she's raising, Chair, between a caregiver and a caregiver with a hyphen. The spelling can be easily confused. She argues there's also no clarity of the reason the definition of caregiver is limited to qualified persons, as it is proposed in the bill that the qualified person must have the accreditation from NSQF training qualification, who are providing care and support services at community-based care facilities, residential facilities, or in similar facilities only. So this definition would exclude family members or any informal support to older persons. She then recommends that if caregiver and caregiver with a hyphen are truly intended to be interpreted differently, a definition of a caregiver with a hyphen should also be included with an explanation of the context in which it is applied. She submits that the inclusion of stakeholders in section 3, subsection 2, she welcomes that one. However, the bill neglects to sufficiently address the multi-level intergovernmental relations between national and provincial social development departments. She seeks clarity as to how the extent to which stakeholders are using the maximum of their available resources in the promotion of interests of other person is to be measured. She proposes that a uniform approach aimed at integrating and coordinating services to other persons can be achieved if national and provincial departments cooperate and coordinate the implementation of Other Persons Act, that OPA stands for that, and recommends that this issue should be addressed in different legislation. With regards to heading of section 7A, so as introduced in section 6 of the bill, she suggests that there should be rephrasing of the heading along the lines of recognition of other persons' role in their communities. And she bases that by saying the current phrasing in the bill, which is responsibility of other persons, is inaccurate as it does not correspond to the text of the section, which aims to ensure that older persons are not prevented from fulfilling their crucial role in society. And then with regard to section 25, subsection A, 5A, it refers that section to old age grant instead of the official name of the grant, which appears in the Social Assistance Act, which is Older Persons Grant. So, and so then her recommendation is that the bill should address the discrepancy by introducing an amendment to Section 25 A to correspond with the definition that is in the Social Assistance Act. With regards to definition of person and juristic person, she submits that the reason for the preference of juristic over natural person as a precondition for registration is unclear in the bill. The proposed amendment to Section 13, read with Section 18 of the Act and introduced by Section 8 and 12 of the bill respectively, will only allow juristic person or trust to be registered and consequently operate legally in terms of the Act. Then if only a juristic person can register and operate and provide services to other person, she then argues that Section 31, subsection 2 will be rendered meaningless. Then the exclusion of natural persons will merely serve to limit other persons' access to social services, which is now the exact opposite of the progressive realizations of the rights of other persons. Then her recommendation is that we reconsider the restriction of persons to allowed to register and legally operate community-based care and support services, home-based care services, or residential facilities to juristic persons and trusts only. And in the alternative, properly motivate the limitation of the scope of application of relevant sections to juristic person and trust only, and then provide a definition for a juristic person. With regard to the insertion of Section 25B to Section 15 of the Act, she submits that no definitions are provided for family care and special care. She welcomes the protection of older persons against abuse and neglect to other persons with disabilities and chronic illness. She further proposes that or recommends that there should be clarification on what is meant by family care and special care. With regard to access to care and support services, she submits that the Older Persons Act is silent on the state's obligation to take steps to progressively increase access to facilities and social services catering for the needs of older persons. Also, the bill does not address this gap and merely takes the model of micromanaging existing services without requiring the state to realize its positive duty to ensure access to social services to other persons. And her recommendation that, okay, I've already covered this one, Chair. Then we have a submission, Chair, from Rand Aid Association. Maybe as upfront, just to mention that it was a one lengthy submission, and mainly it focuses on questions that I think when the department comes in a week or so to provide responses, it will be able to address those questions, because I feel that they'll be more better placed to respond to those questions than as a committee. Okay, as introduction in their submission, Chair, the organization, it confirmed its support for quality service for older persons and the need for statutory measures to ensure protections of the most vulnerable section of the population. It also understands the shortcomings of the Older Persons Act and supports the proposed amendment, particularly the amendment to remove older persons from an unsafe situation. However, it noted that in the memorandum of the bill, it is mentioned that it was consulted, but it wants to put it on record that this was not the case. It only submitted comments, but it was never consulted on the proposed amendments. Okay, and then it submits that the bill, despite its noble intention, it may have unintended consequences as it puts more focus on registration and control of type of services and even accommodation options where retired people invested their own funds and opted to leave. It argues that the country has a growing population of older persons and is in dire need of support and accommodation. Thus, the focus should be on creating an enabling environment that will encourage service providers to develop and implement a wide range of services by giving support and services. The registration and control should only apply where the most vulnerable and frail care are catered for on a 24-hour basis. It is understandable that government subsidies necessitate certain controls and requirements, but these do not have to be legislated, as they can be conditions of financing, such as the number and type of services to be provided, and whether it is a 24-hour care facility or it is a home-based care program. It also submits that it fears that the bill criminalizes all unregistered community-based services and housing facilities or development, and when read together with existing Act norms and standards in the regulations, there are onerous demands that are placed on service providers, particularly on community-based care and support services. It is not clear why housing developments for independent older persons, which are already regulated by other legislation, are included for registration in terms of this bill. And then it argues that if measures to hold liable those who abuse and exploit other persons were taken seriously and are adequately and efficiently implemented, it is not necessary to register each activity related to other persons. Then it submits that the grouping together housing developments for independent older persons with residential care services will create confusion. It argues that this approach makes housing development subject to norms and standards for residential facilities, which were drafted with 24-hour frail care facility in mind. The norms and standards cannot be applied to housing development, such as retirement villages, because they are governed by sectional title legislation or were sold on a freehold basis. It further submits that some of the proposals regarding housing facilities encroach on the right of older persons to make decisions for themselves and lead independent lives. It submits that the bill creates unnecessary blanket action relating to any kind of service to older persons. Then recommends that the bill should create an enabling service environment without contradictions and inconsistencies. Okay, then with regard to the general issues it wanted to raise, it questions how, excuse me, Chair, can I just address something? Just quickly, I'll be back. Just shortly, Chair. Thank you, Chair. There was a kind of a background noise. Okay, Chair, let me just start this one. It questions how the department is going to register all housing developments and community-based services in addition to the workload of registering and monitoring 24-hour fair care facilities when it is already under strain. It points out that it took more than 10 years to register or re-register the 24-hour care facilities for older persons, which were previously known as audit homes. And many of the provisions of the Act, the 2006 Act, they remain outstanding, for example, the registration of care workers. With regard to the costing of the bill, it submits that the costing of the bill was made 5 years ago, and there's been recent subsidy cuts in Gauteng, and there's been an impact of the COVID-19 and the load shedding on the economy. So how is the bill envisaged to be covered? It questions if it is envisaged that the number of staff in the department will be increased to meet the requirements of the proposed amendments, and will such an increase in staff impact on the funds available for the subsidization of NPOs providing essential care and protection services. With regard to restrictions on service developments, here the organization argues that the Act is supposed to encourage service delivery to older persons. By implementing all these requirements for registration and control, as well as detailed operational standards determined in the regulation, it becomes more difficult, almost impossible for service providers to develop and implement services. It then questions why in community services such as recreational, information sharing, spiritual, meals, and intergenerational programs must be registered. Regulations contain strict criteria on how many primary services must be rendered and how many times a week. If no funding is requested, what is the purpose then of these restrictions? E.g., a church operating a soup kitchen in a community. Then it submits that currently this is illegal if a facility like the church is not registered, leading to other persons missing out on assistance and support. Subsidy criteria should not be applied in a broad brush approach to all support services. It foresees that the same will happen with the housing development. Still on the issue of the housing development, Chair, it makes reference to this Act, the Housing Development Schemes for Retired Persons Act of 1988. It submits that reference to an inclusion of housing development governed by this Act should be reviewed. That is their inclusion in the bill. It raised the following contradictions and inconsistencies. To all housing development fall under the auspices of Older Persons Act, or only those that cater for persons 60 years or older? What happens in the case of developments where people younger and older than 60 years are catered for together? Then it argues that it is inconceivable that the minister can have the powers to close a housing development operating in terms of a sectional title, a share block, a freehold, or life rights development. What happens to the capital invested by older persons in their own privately purchased houses, flat apartments, to which they may hold a registered title? Is it envisaged that the minister can be empowered to take away such property rights? Then now, Chair, it focuses more now on the sections of the bill, being the first one on definitions, which is clause 1, the definition of assisted living. Maybe I can just read quickly, Chair, what the proposal is in the Act. In the amendment bill, assisted living facility means a residential facility used for provision of safe and accessible accommodation with access to care and support services to older persons who are partially independent, with or without assisting devices, and who need some form of supervision and assistance with their activities of daily living. So it's for older persons who are partially independent, Chair, who may or need some form of supervision. I'm emphasizing that because that's the main focus of the submission or on the argument of this organization. So it says here, it questions the use of residential facility in the definition of assisted living. In relation to the definition of residential facility, referring to 24-hour care and accommodation and provisions of services. Now, Chair, if I can read now the definition of residential facility, because the main argument centers around these two definitions, Chair. So the residential facility, as proposed in the bill, it says it means a building or other structure that is used primarily for 24-hour care, accommodation, and the provision of services to older persons in both public and private residential facilities, and includes assisted living independent living, frail care, and similar facilities. So that's what the residential facilities is defined, is how it's defined in the bill. Back to what the organization is saying. So it says the bill defines care to include physical, psychological, social, spiritual, nursing, first aid, or material assistance. Thus, this cannot be the intention for assisted living, bearing in mind assisted living is for the partially independent older persons. The organization argues that this is an example of overreach for this proposed definition. It also questions the intention of safe and accessible in the definition of assisted living facility. Is it related to security? Is it accessible to disabled person? Is accessible use in relation to affordability? So it poses those questions. And then under the definition of care, the organization argues that the broad scope of the definition of care has a serious impact on other definitions and services, such as caregiver, which is provided below. It submits that the definition of caregiver, that due to the broad definition of care, it becomes problematic to determine who is regarded as a caregiver. For example, due to the inclusion of spiritual care, is it the intention that a priest should be regarded as a caregiver? Similarly with nursing, is the nurse a caregiver? Also, will social and psychological support imply a social worker or a therapist, or a therapist is a caregiver? Just to remind members how caregiver is defined in the bill as proposed. A caregiver means any person who provides care and support services, whether at a community-based care facility, residential facility, or similar facility, and who has been accredited with the National Qualifications Framework training qualification appropriate for the care of older persons. Okay. The organization also questioned what is meant by similar facility. It also appears in other definitions, it also appears in a few other definitions. If it is not known, then it suggests that it should be deleted everywhere it appears. The definition of frail care facility, the organization points out that the definition also describes frail care facility as a residential facility where primary 24-hour service are provided to frail care persons. Then it recommends that 24-hour care service be deleted from the definition of residential facility. With regard to independent living facility, the definition of it, the organization points out that the independent living is defined as a residential facility that provides accommodation to fully independent active older person. It then questions if the intention is that no care may be provided in these facilities, or an older person may not age in place as it is the norm worldwide. The agency of older person is thus taken away in this bill. With regard to the interdepartmental structure, the organization poses these questions. Why is it needed? What has happened in the past with cross-departmental responsibilities? Is this not covered elsewhere in public service legislation or guidelines? Who is to establish this structure? More importantly, how can an interdepartmental structure include a civil society organization or any person? Is this a natural person or again a juristic person? It seems strange to involve natural persons here, but not allow them to operate any facility. If this remains, who and how will these persons be chosen? With the definition of manager, The organization questions the intention of the proposed definition. Is it for the management of a residential facility or similar facility in an institution? Both terms are not defined. Or any program for rendering services which has a very broad definition in the 2006 Act and any other activity or program. Those are services that now appear in the Older Persons Act and to older persons, even the recreation program. Definition of person. The organization argues that the proposed limitations in respect of registration and operation of community-based care and support services, home-based care and residential facilities to mean only a juristic person or a trust will be extremely limiting to any individual who has or would like to provide any support service to older persons, such as running a soup kitchen or providing a recreational service. With regard to private residential facility, the definition of it, the organization questions the intention, the proposed requirement for registration of this facility when the HDSRP Act, the one that I referred to earlier, Chair, does not provide for it. It points out that there are various ways of operating a development scheme in terms of the HDSRP Act, but no central register exists because of this fact. If developed, for example, as a sectional title scheme, the scheme will be registered in the relevant deeds office, or if a share block scheme, it will be at the CIPC, which is Companies and Intellectual Property Commission. Then it poses this question: what is the difference between private residential facility and independent living facility? Both encompass accommodation or housing for independent older persons. Is the contention that only those facilities governed by the HDSRP Act are private and the other is run by government? That is not the case, as most of the independent living facilities were established by private groups such as NPOs or developers. So what is meant by private? The definition of residential facility, the organization points out that the proposed definition refers to a building or structure that is used primarily for the 24-hour care and includes both public and private residential facility as redefined. How is primarily for 24-hour care compatible with assisted living and independent living, both used in the definition of residential facility? The organization then submits that reference to public and private residential facility in this definition is problematic, as the term being defined is used in the definition of the same term. It seems the definition also covers a private residence where an older person will be accommodated and is provided with services. Is this why a private residential facility is defined as an established or registered in terms of the HDSRP Act? But then every house or cottage or unit in such a development must be registered. Again, surely that cannot be the intention it submits. With regard to clause 18, subsection 1B, it submits that it only excludes private residence where an older person is looked after by a family member. It is unclear how this can work. The HDSRP already provides in section 5 that care facilities in a housing scheme should be registered as a home of the aged as defined in the Aged Persons Act of 1967. With regard to the stakeholder, the organization questions the definition as it is government's responsibility to look after citizens and their rights as stated in the Constitution, Article 7.2. It argues that the burdens imposed by the bill on stakeholders are cumbersome, and it is almost as if it is expected of them, that is the stakeholders, to undertake the duties imposed on government. There is also a principal issue and dichotomy, private persons are regarded as stakeholders with onerous duties, but they are not allowed to deliver services. With regard to temporary safe care, the organization questions what will happen after the 6 months has lapsed of the temporary safe care. Can the period be extended if the circumstances warrant it? It seems this has not been thought through, as was the definition in the earlier bill. Going to clause 2, the organization welcomes the inclusion of reference to laws and policies of vulnerability, aging, disability, and families. It is of the view that this stresses the focus of Older Persons Act to serve other persons and not control and limit their lives and contributions to community. However, whilst it supports measures to protect older persons, it questions why people with disabilities are not granted the same protection. There is no act to regulate residential or non-residential care for disabled adults. Clause 3, subsection 3.1, stakeholders are not to implement the act. This cannot be the intention of this proposal as it appears in the bill. They are, however, to comply with all relevant legislation, and that should be monitored by the organs of state it submits. With regards to clause 3, subsection 2, stakeholders in the private sector are already stretched to maximize positive impact for older persons with limited state financial and other support. It is illogical to enact a legislation to impose duties on the private sector to achieve the objects of the Act. Duties can only be imposed where the state funds the private sector to implement certain programs and services. The private sector operates voluntarily, whether on a non-profit basis or for a gain. With clause 3, section 3, this amendment is too prescriptive, as the Rand Association submits. How is it envisaged this uniform approach is to be applied? Will it be monitored, and if so, by whom? Clause 3, subsection 4, the use of as prescribed. Should the department not be doing this in any event in terms of Constitution, Article 85 and 125, and Chapter 3 of the Public Service Act? Clause 3, subsection 5, the provincial plans. This inclusion is self-evident. What is meant with provincial plans? Or is it meant to refer to provincial programs referred to in regulations of the 2006 Act? Clause 4, the amendment is not the place for stakeholders. This is to confirm the responsibility that the proposal in the bill. The organization says it is meant to confirm the responsibility of the state and its organs in relation to other persons and how to protect them and promote their rights. It is covered by Section 5, subsection 2 of the Act. Clause 5, the amendment is, of course, is not in place for stakeholders, and the argument it raises that the implementation is the responsibility of the state and its organs. Due to the wide definition of stakeholders and services, one can even go to the extreme to infer that the retail sector, banking sector, tourism sector, etc., who all have programs for older persons, should base their decisions on the guidelines in the Act and be responsible for its implementation. And that is already covered by Section 5.2 of the Act. Okay, with regard to Section 6, the insertion of Section 7A and 7B. 7A, the heading and introductory line do not make sense. How can an older person, okay, now taking the phrase from the bill, how can an older person may not be denied the right be a responsibility of older person as in the heading? These are good suggestions to be included in a charter or policy or a plan. What must the older person mediate, or which conflict are they responsible to resolve? Section 7B, wide inclusion of based on gender in subsection A. Surely the protection should apply to all older persons. Clause 7 imposes this question: is focus only on non-communicable chronic diseases? Why not all non-communicable diseases or all diseases? What is the reasoning behind this? In the proposed section 25B, the heading refers to older persons with disability and chronic illness. Is a chronic illness the same as a non-communicable chronic disease? It asks. With clause 8, the definition of persons refers to not only community-based care and support services, but also home-based care and residential facilities in relation to the registration and operation of all of this. Is there not a duplication or contradiction, or wider and more limited in different areas? With regard to section 1A, while an object of the Act is to promote the well-being of other persons, here the Act or the bill takes away any initiative an individual or religious group or body of individual might take to assist in enhancing the well-being of other persons or delivering a service to other persons. Is this the object of this new section? It does not make any sense. Many current services, whether formal or informal, will be terminated with devastating implications for probably hundreds of other persons. Were the cost of registering and managing and running a trust or juristic person considered in formulating this proposal? Should registration of community-based services not only apply where state funding and subsidies are sought? With clause 9, the prescribed training remains uncertain. This is with regard to training of caregivers. Are there different curricula already approved? Where can it be obtained? Also, are the providers of training accredited by SACA? Is there a central register? Is it accessible electronically for all stakeholders? With clause 10, this section is not clear. Section 22 of the Act applies to the monitoring of registered residential facilities, not even registered residential care facilities. If monitoring and evaluation of the community-based care and support services is subject to this section, and to the extent that this section applies, it has the effect that none of the community-based services can be monitored in terms of section 22 or the new section 15. Clause 11, with its amendment to section 17K, does not make sense whether there is reference to special care in the case of assisted living when one considers the current proposed definition of assisted living. What specialist care is provided in assisted living facilities? With regard to section 17, subsection I, it submits that there appears again the term safe and accessible, and what is meant by that. Clause 12, 1A, this subsection also includes the very wide wording of all similar facility. So again, what does this mean? And then it submits that it does not make sense where there are already so many prescriptions regarding planning, development, and building that the Department of Social Development now also needs to participate in the process of providing housing or accommodation. There is a general need for housing in the country. It should not be planned to make it even more difficult to develop housing. Subsection 2, this subsection now only allows for a trust or a juristic person to operate a residential facility, which it goes with the same arguments. They want to understand why it should be a trust or a juristic person and not any natural person. Developments for independent older person run by the residents or owners in the case of sectional titles or share block schemes or their agents should not be subjected to onerous registration requirements. One of the general principles of the 2006 Act, Section 5.2, states that actions and decisions must respect, promote, and fulfill the older person's right, respect older persons' dignity, treat older persons fairly and equitably. Here, the rights are taken away, being infringed upon, and they are treated as if they are incompetent. This is a gravely discriminatory interpretation or framing of an act supposed to support older persons. In section 25A and 25B, it recommends that it should be made clear which social workers are allowed to remove an older person without a court order. This cannot be left open for any social worker to undertake due to the extent and implications of this intervention. Clause 13, the new proposal granting powers to the DG to close independent schemes, e.g. the sectional title schemes, are a total overreach and impact on the human rights of individual older persons who bought units in these schemes or who have acquired life rights. These are properties purchased by older persons and, in the case of sectional title, where they have title deeds registered in the deeds office. In terms of share block and life rights scheme, there are legal contracts governing ownership and use. How can these be taken away and services closed? The registration and deregistration process are understandable where government subsidies or 24-hour frail care facilities are applicable. But closing independent living development is not possible. Clause 14, subsection 3B would have relevant inserted before provincial department in line 1 to correspond with subsection 2A. That is now a proposal on this one, Chair. And then it submits, it is interesting that a social worker in private practice is not included in this section. What was this an oversight? In practice, quite a number of older persons is supported by social workers in private practice, and they can be very useful in the circumstances envisaged in this section. Furthermore, the definition of social worker in the Act also refers to a social worker employed by a registered welfare organization. As far as the organization that is now Rent Aid Association is aware, the previous legislation to register welfare organization has not been applied for years and may have been repealed, which is now the National Welfare Act of 1976. How are social workers going to be accredited as being in the employ of a registered welfare organization? It cannot just be accepted that a social worker in the employ of a registered non-profit organization is now employed by a registered welfare organization. There is no provision in the Non-Profit Organization Act to accredit non-profit organizations as welfare organizations, and thus the definition of social worker in the 2006 Act cannot be applied. The department itself describes the register of non-profit organization as a voluntary registration facility. This process does not include any verification of services, standards, or controls. This legislation relates to the fundraising aspects and not any accreditation of social work practices. Section 25B1 and subsection 1 and 2, it poses these questions. What is meant by family care or special care? Who will assess when is it appropriate? Why highlight disabilities and chronic illness in the bill? These can be managed in regulations, charters, policies, or plans. There are also examples, for example, mental health illness that are not disabilities. Dignity, well-being, participation of all other persons are important, not only that of persons with disabilities or chronic illnesses. It does not serve a purpose to identify subgroups and label them. Clause 16, subsections 1 and 4, the use of manager is still odd, as there is a definition of manager which has also been amended in this bill, but this might have another intention. Also, is it appropriate to allow a manager of a facility, qualifications are known, to investigate suspicions of abuse? What is intended here? Is it just a preliminary investigation prior to reporting to a social worker or the police? The facility manager cannot, in terms of Section 25, remove the older person and take the other steps described in Section 25. The facility manager, like any other professionals, should report the matter to the DG or social worker as provided for in Section 25, subsection 1. In clause 17, the privilege against self-incrimination must be considered and kept in mind. Possibly also the stipulations of the Criminal Procedure Act 51 of 1977 and the rights a person has in terms of the Constitution. Then it says, while the language of other person understands, that is now a provision that is in the proposal, and not selects. It supports clause 18, and these other clauses, it also support them, Chair. Okay, now we move into Ilita Labantu. The organization welcomes the purpose of the bill and its proposed amendments, the insertion of new definitions, provisions of monitoring and evaluation, removal of other persons to a temporary place of safe care without a court order, strengthening of implementation and compliance measures. It also welcomes the insertion of a new and improved definitions, which will help to ensure that services provided to other persons meet established standards of quality. It points out that there have been deficiencies in the provision of services to other persons because of limitations in definitions. It particularly welcomes the redefinition of an older person, as it is of the view that it will ensure that older persons will be equally entitled to benefits and protection. This is because the qualifying age of 65 years to older men placed serious limitations on their access to benefits. Clause 2, the organization welcomes the recognition and provision of the specific needs and preferences for older persons so that services can be, where am I now? Sorry. Okay, can be tailor-made to meet the diverse requirements of South African elderly population. It notes that preventative measures against abuse means there is an effort to ensure that a society that respects the rights and well-being of other persons is fostered. Clause 3, Ilita Labantu also welcomes the contribution that must be made by government entities, including stakeholders, who must be coordinated so as to provide integrated service, thus ensuring accountability. Clause 4 to 5, the organization welcomes these sections as they establish indicators and benchmarks that make it possible to assess the effectiveness and efficiency of the services for other persons. It notes that the identification of harmful traditional practices, including witchcraft accusations, which may, okay, I think there's something missing here, may hamper the welfare, health, and life and dignity of other persons, addresses the shortcoming that has been prevalent in certain communities where community members take law into their hands and bring insufferable harm to other persons accused of such. Older persons who suffer from dementia are labeled as witches and some are killed. In section of 7A and B, It welcomes the sessions of 7A and B as it allows for intergenerational dialogue and solidarity within communities and aids in passing traditions and heritage. This shows that DST recognizes the value of older persons. Older persons' rights have been violated regarding property and inheritance. Older persons who are illiterate have been coerced into signing documents that have resulted in them losing their homes or possessions. Clause 10 to 15, it submits that regular monitoring and evaluation provide an opportunity to identify innovative approaches and make adjustments to enhance the effectiveness and efficiency of services aimed at improving the well-being and rights of older persons. Organizations need to constantly adapt and respond to evolving needs of older persons and ensure that their services remain relevant and of high quality under the supervision of DST. It recommends that the bill should provide for strengthened penalties for non-compliance and also dealing with offenders. Reporting mechanisms for older persons to report abuse, such as helplines, hotlines, or online reporting platforms should be made available. Clause 16 to 23, the organization notes that inclusion of social workers, managers, police officers, and procedures to deal with perpetrators of abuse against older persons ensures that there is a comprehensive protection of older persons. It also notes the inclusion of neglect and exploitation in the definition of older persons. Now we are in the National House of Traditional Leaders. The House supports the bill and expects it to have a positive impact on the lives of older persons if properly implemented. It recommends that the bill must also include verbal and emotional abuse. Submits that the means test disqualifies deserving older persons only because their spouses were civil servants. It recommends that the means test must be removed or changed to have every elderly person to receive social grant irrespective of the financial status of their spouses. With regards to clause 1 in definitions of assisted living facility, it is not clear what is meant by partially independent as opposed to independent older persons. Using terminology in this manner may result in the term having different interpretations. The term affordable is vague and may be difficult to measure. This is because within specific facility, the levels of affordability may differ, and some may consider the fees affordable, others not. Insertion of Section 7A, it is welcomed, and the traditional leaders and their traditional councils must be involved in dispute resolution in families and traditional communities in matters affecting older persons. Traditional courts may also be used to resolve disputes through restorative justice. In Section 25A, the House raises a concern about this clause, about the removal of older persons without consent from older person or court order without sufficient evidence. It recommends, in the absence of a court order and in the inability of the older person to provide consent, the duly authorized person must be provided with sufficient information to make an informed decision. The right of privacy of an older person and personal information of an older person must be protected. Okay, there should be a clause in the bill to provide for any person entrusted with the care of older persons to face consequences for improper conduct of care and negligence of care of older persons. States should enforce consequence management to any person who mistreats older persons. The submission from the Western Cape government. The general comments, the Western Cape government raises concerns around the implementation of the services provided for and the costing of the bill. It raises a question if the additional costing and its impact on the provinces was adequately considered in the socio-economic impact assessment. The Western Cape government has no fiscal room to reprioritize further without harming other critical provincial services. The national funding strategy should look at norms and standards across the sector as a whole to reduce the cost of non-essential mandatory social development services for provinces. It recommends that the implementation of all the proposals in the bill must be subjected to formal costing. Adequate additional resources must be provided to provincial departments to perform these functions. The Financial and Fiscal Commission should also be consulted given the intergovernmental fiscal impacts of the amendment bill. With regard to caregivers, more clarity should be provided in the bill as to the roles and responsibilities of persons who do not fall within the current proposals for the definition of caregiver. For example, a person who is not accredited as a caregiver volunteers to serve or care for another person by agreement between them where home-based care is not available. Would such person fall foul of the intended legislation for not having necessary qualifications? What about family members who do not reside with the older person, but render care to the older person within the meaning of the term care as defined? If the scope of the definition of caregiver is too restrictive and only acknowledging those persons with accredited qualifications to be caregivers, could this mean that any person providing care, even with the consent of the older person, will be acting unlawful or unlawfully? The recommendation, the bill needs to provide better guidance as to the role, status, and responsibilities of persons in general, not only caregivers as defined, who provide care to other persons. With regard to clause 1, the words used for the provisioning of safe and accessible accommodation to other person needs consideration. Compare the wording in the definition of assisted living facility as described as a residential facility used for the provision of safe and accessible accommodation. The word provisioning is more conducive to the provisioning of food or money, not accommodation. Then it recommends that the wording in the definitions applicable to different kinds of residential facilities be aligned for purposes of consistency, and that the word provisioning not to be used in this context. Definition of interdepartmental structure, it proposes that there must be a correction in terms of South African Police Services to South African Police Service, in keeping with the provisions of the South African Police Service Act of 1995. In clause 3, the Western Cape government's concerns centers around the costing of the additional responsibilities of the proposed coordination between the Office of the Premier and the Provincial Government of Social Development regarding the coordination of provincial plans and the implementation of this act as may be prescribed. The latter proposal suggests that there may be regulations in the pipeline to this effect. These additional responsibilities necessitate additional capacity and resources. And given the current fiscal constraints, the Provincial Department of Social Development, that is the Western Cape, does not have the financial resources to implement these additional functions or mandates. The implementation, it then recommends that the implementation of all the proposals in the bill must be subject to formal costing. Adequate additional resources must be provided to provincial departments to perform these duties. This proposal should be amended to the effect that the Provincial Department of Social Development is the lead in facilitating and coordinating the development of integrated provision plans, and that the Office of the Premier approves the plans. Clause 5, Section 4, it recommends that this subsection be added as a section to Chapter 5 entitled Protection for Older Persons. The word practice should be, okay, this one, Chairperson, I went back to the submission and it is as it appears here. It kind of like confused me what they're trying to say here. but it appears as it is here, the word practices should be practices since it is a verb. I'm not quite sure, maybe I can be assisted here, but I did verify this this submission. It appears as such in the original submission, Chair. The phrase harmful traditional practices should be defined. Specificity is required as to the meaning of taking all measures necessary to eliminate harmful traditional practices. Clause 6. The Western Cape government suggests that the content of this proposed section be included as subsection G, H, and I under section 7 entitled Right of Persons of Other Persons as follows. 7. Rights of other persons. Other persons may enjoy the rights contemplated in Section 9 of the Constitution of the Republic of South Africa, and in particular may not be unfairly denied the right to F. Access opportunities that promote his or her optimal level of social, physical, mental, and emotional well-being. G. Mentor and pass on knowledge and experience to a younger person. H. Foster and facilitate intergenerational dialogue and solidarity within his or her family or community. And I. Play a role in mediation and conflict resolution. Alternatively, current subsections under subsection 7 can be enhanced to include the content of subsection G to I, where there is an overlapping content. In section of 7A and 7B, it recommends if proposals to the intended section 7A are incorporated, the intended section B should then be renumbered as section A. Since the content of section B deals with the rights of other persons, the reference to physical abuse in the heading should refer to the right to bodily integrity, referred to in subsection 12, 2 and B of the Constitution of the Republic of South Africa. Therefore, reword the heading as follows: protection of rights to property, inheritance, and bodily integrity of other person. Clause 8 suggests that reasonable time periods for the notification procedures be inserted in subsection 4. This aims to prevent any disadvantaged other person who will be affected by a determination of services. Clause 9. The additional training provision of caregivers as contemplated in proposals to section 4, subsection 1, requires additional capacity and resources. Given the current fiscal constraints, the Department of Social Development in the Western Cape does not have the financial resources for implementation. Then it recommends the implementation of all the proposals in the bill must be subject to formal costing. Adequate additional resources must be provided to provincial departments to perform these duties. In clause 12, the inclusion of additional entities for registration of private residential facilities, assisted living facilities, or similar facilities extends the scope of registration of facilities, thereby increasing the need for capacity and resources. Given the current fiscal constraints, the provincial department does not have the financial resources to implement. Then recommends the implementation of all the proposals in the bill must be subject to formal costing, and adequate additional resources must be provided to provincial department to perform these duties, these services. Okay, this was correcting the police, that there must be cross-reference to a police official, since this is defined in terms of the Act, the South African Police Service, or that the term police should be corrected to police official, since this is a defined term in the Act, or the bill should use the South African Police Service. Clause 15, the Western Cape government points out that as a province, it has a high level of longevity, than in the rest of the country, and thus faces even greater demand for placement as such facilities. So given the current fiscal constraints, the Provincial Department of Social Development in the Western Cape does not have the additional financial resources to implement these functions or mandates as proposed in clause 15. Then it recommends the implementation of this clause in the bill must be subject to formal costing. Adequate additional resources must be provided to provincial departments to ensure temporal safe care placements. Then liability for temporary safe care. Temporary safe care is contemplated as a shelter or any other place. The word shelter is defined in the Act as any building or premises maintained or used for the reception, protection, and temporary care of other person in need of care and protection. Any other place has a broad meaning. It could include the residential facility referred to in the Act or the bill. It could also include other private or public services, facilities. This again leads to the question as to what is to happen in the event of costs to accommodate other person in need of temporary care. The bill needs to identify the persons or authority responsible for the cost of temporary safe care for a period not exceeding 6 months. It recommends that clarity should be provided in the bill as to the liability of the state for payment of temporary accommodation for other persons for a period not exceeding 6 months. The proposed section 25A 6, in terms of this proposal, misuse of a power by a social worker constitute misconduct as contemplated in section 27(1)(b) of the Social Service Professions Act. Section 27(1)(b) of the Act empowers the minister to make rules relating to the acts or commissions or omissions of, among others, persons, social workers, which shall constitute unprofessional or improper conduct. And then it states that there are other number of sets of regulations made under this Act. The correct set of regulations and the relevant provision in those regulations must be identified for purposes of this insertion. Then it recommends that you correct the reference to section 27(1)(b) of this Social Service Professions Act of 1978. Clause 16, the receipt of complaints and the responsibility to investigate within the prescribed turnaround time as contemplated requires additional capacity and financial resources. The resource mobilization as contemplated in this clause must be subject to formal costing and the provisions of additional adequate resources to provincial departments to perform these functions. Then, given the current fiscal constraints, the Provincial Department of Social Development in the Western Cape does not have the financial resources to implement these additional functions and mandates. And then it recommends implementation of this clause in the bill must be subject to formal costing, and adequate additional resources must be provided to provincial department to ensure temporary safe care placement. Clause 17. The reference to section 319, subsection 3 of the Criminal Procedure Act of 1955 does not appear to be correct. The proposed amendment contemplates a charge, but this provision of the Criminal Procedure Act of 1995 refers to a reservation of a question of law. And therefore it says there must be, correction must be made in referencing the Criminal Procedure Act. In clause 18, the definition of physical abuse can be expanded. Physical abuse can constitute an act or a threat of violence, as stated, but also an omission which results in physical harm. The list of actions after the word including would make better sense if the definition were expanded to include omissions as suggested. Then regarding to medical sedation or shackling as contemplated, the administering of any kind of medicine, not just medicine with which causes sedation, or substance or drug without consent of the older person and contrary to the older person's best interest could also constitute physical abuse. So the recommendation is there must be further consideration given to the definition of physical abuse. COSATU supports the bill and perceives it as a long overdue intervention to ensure the protection, security, care, and dignity of elderly. It acknowledges that the bill also ensures that those entrusted with their care, which is other person's care, are held accountable. It also supports the bill, specifically those that provide for the following: the right to comfort, ensuring that older person's retirement is one of dignity, is to ensure that their comfort is to be recognized. In terms of facilities, supports the powers provided to the state to register, suspend, and close any facilities that fail to comply with their obligations under the Act at any time. Additionally, it supports the enforcement of monitoring and evaluation of community-based care to be always held accountable. Caregivers, it supports the registration of caregivers to make sure that only those who are competent are allowed to render services to older persons. With regards to stakeholders, it supports the amendment of Section 3B of the bill as it recognizes stakeholders, including civil society, that plays a role in caring for and providing services for older persons. In section of Section 7A and B, it supports the fact that community members will have authority to report elderly abuse to the relevant authorities. And then it points out many elderly are subject to serious abuse by family members, estate agents, and others who seek to exploit their vulnerability and access their inheritance. Provincial governments play a significant role in terms of services for older persons. So COSATU then indicated that this important stakeholder has neglected investment in what is rapidly growing need for society as society and culture evolves and change. That is now the provincial governments. It welcomes the proposed amendment, which requires educational support and special care for the elderly with regard to NCDs and chronic diseases. The elderly are extremely high risk of infection, and chronic diseases increase with age. Temporary safe care, it supports the provision of temporary safe care for the elderly who have been victims of abuse to be removed from dangerous environment. And it also welcomes the proposed extended definition of physical abuse. From Dear South Africa, this one, Chairperson, it is a submission that I think people, they subscribe to this organization, which is Dear South Africa, and it comes to Parliament, or it is a submission is made through emails that come from various members of the public. So we received a submission from 168 individuals, and 163 of them did not support the bill. However, they were not really specific, what exactly, which proposals they're not supporting. But going through their submissions, my assumption would be the proposed amendment one about removing an older person to a temporary safe care. So their submission was that I'm not quite sure if they maybe understood what this meant or what is the intention of that amendment, but their submissions, all of them mainly focus on them not supporting the bill because they are opposed to the removal of older persons without permission. They argued that older people have a right to voice their opinions and are a very important part of the society. They are still able to think and do things for themselves. Therefore, the bill is an infringement to the rights of older persons. This, in essence, Chairperson, what was contained in the whole of 168 individual submissions, which were mainly like a liner or 2 lines in the email form. Then 2 that did not indicate, and then 5 supported the bill. Then we had a submission from Mr. Johan Rademir, the one I explained earlier. It was submitted when we were in PAL, but however, he indicated that he wants to make oral submission, so I've included it here. Then his submission goes as follows. With regard to abdication of responsibilities, he raised a concern about government abdication of its responsibilities towards older persons and shifting such responsibilities more and more towards the already heavily overburdened private sector. And at the same time, it imposes more and more legal requirements to service providers to provide for basic grants. The municipal bylaws, a municipality impose stringent bylaws that require millions of rands to spend to make buildings compliant. Such expenditure impact on the already limited budgets of the centers, resulting in them cutting back on quality of service and reducing staff members. Then he recommends government should pay for the implementation of bylaws or the levels of the bylaws be lowered to manageable standards. Training of caregivers. The proposed amendment imposes yet more requirements that must be implemented by the private sector to comply in providing statutory services. The removal of older persons to temporary safe care. He wants to know where these facilities are located. He argues that this is another pipe dream of government, which the private sector has to come up with a solution and pay for it. Funding of service centers for older persons. These centers play an important role in rendering services for older persons, but their funding has been capped at 260 members, making it financially impossible to roll out services. The submission from CPLO, it welcomes the insertion of definitions, particularly those relating to the monitoring and evaluation of all services to older persons. The extended definition of rehabilitations, it's also welcome as this proposal, it welcomes this proposal as there is a wide range of physical and occupational therapies which can do much to enrich the lives of all people. Definition of care, the inclusion of spiritual care resonates with the Catholic Church. The recognition of the importance of the spiritual dimension in the care and comfort of older person is a holistic and comforting approach. Then it recommends that families should also have access to counseling and support. Support groups for families of those with particular conditions such as Alzheimer's should be encouraged and facilitated. The removal of older persons to temporary safe care, it submits that this should be done in the best interest of the individual. Then access to health care. Older persons, especially those with impaired mobility, chronic health conditions, and advancing frailty, particularly those in rural areas, have difficulty accessing primary health care. Then the CPLO, it cited findings from the South African Human Rights Commission, which noted that older persons, particularly those who live in rural areas and those who are poor and ill, are mostly adversely impacted when they try to access healthcare. So this is a service delivery issue, Chair. Then accusation of witchcraft accusation. It welcomes the attention given to witchcraft in the bill, as witchcraft-related violence continues to plague rural areas, predominantly targeting elderly women in these provinces in Limpopo, Mpumalanga, Eastern Cape, and KwaZulu-Natal. Then it recommends there should be more education of the public about Alzheimer's disease and dementia by DSD and the Department of Health to promote greater understanding of the effects of old age. Education should also include necessary measures to eliminate harmful traditional practices that include witchcraft accusation, which affect the welfare, the health, the life, and dignity of older persons. And then the register of abuse of older persons, it submits that the incidence of older person abuse in South Africa is not clear. Elder abuse generally does not receive the same attention from researchers and other forms of interpersonal violence as other forms of interpersonal violence. In the broad context of global aging, little is known about the experiences of abused older persons. Often cases of elder abuse are not registered, and when reported to the police, such cases are classified under general or indecent assault or murder. Okay, the last slide, Chair. CPLO, it knows that the Children's Act and the Sexual Offences Act make provision for similar registries as the Register of Abuse of Older Persons. It urges that for these registries are to be part of protective strategies to protect vulnerable. Measures must be put in place to ensure their success. Thus far, however, the existing registers have met with little success and have been poorly maintained. And then during the public hearings regarding both the Children's Act and the Sexual Offences Act, it was suggested that such offences should be included in the criminal record. And this is the only record that is regularly maintained and updated. Chair, that's the end of the submissions that we had received. Thank you, Chair. I am done, Chairperson.
Okay, thank you.
Yoli.
Yoli.
Sakhanya.
Yoli.
You flew,
Thank you
Chair,
very much,
flew.
Yoli. I am dear Makar and also tired. I'm sorry for that. Yoli, thank you very much. It was long, and also I think honorable members have managed to go through it, even if one couldn't finish it. It's so complicated. Other things we know for a fact that they will definitely oppose them. Other things are really irrelevant. But let me give the honorable members to discuss on it and get on it. Lindy, what is the approach now? It's the deliberations, ne?
Chair, the process is for Yoli to sensitize you or capacitate the members on submission received, so that when it's the deliberation time and then the responses from the department, because the department to respond to the issues that are raised in these submissions, there will be a time for the department to respond whether a certain proposal is implementable or not. So it might be clarity-seeking questions, which I don't know whether you will be able to respond to, because she was just summarizing the submissions from various stakeholders. But now it's a matter of just capacitate members, sensitize members as to these are the issues that came during the submission period from various stakeholders. And then about 5 organizations, 6 will come and present their oral submission next week. Is Elita Labantu, Kosatu, Mr. Aranda Meyer, and about another 2, about another 2 stakeholders. I will send the program will come and present their submissions next week on Wednesday, Chair. So that's how that's the advice I can give, is to say that we wanted to equip you for the hearings, and also to inform you as to what are the key issues that came from the public as far as this piece of legislation is concerned, Chair. Maybe if there is a clarity-seeking questions, and member can just raise. I just wanted to say what will be the process going forward. Thank you, Chair.
Thank you, Lindy. Is it out of the presentation that Yoli has done? Because I heard that the little amount also submitted and Yoli read it. And in terms of these ones that are supposed to even what is it? The COSATU, is it COSATU that have also submit? Are they gonna submit for the second time? What's going to happen?
Okay, Chair. During our advertisement, in the national newspaper and provincial newspapers, we requested the public to make input in this piece of legislation. And if
Yes.
they want to make oral presentation, they should indicate so. So out of
Okay.
the presentation we have received, about 5 organizations indicated that they want to appear before the committee and make an oral presentation to the committee. So what Yoli has just summarized, it is what they are going to present before you on Wednesday. So it will be just the repetition, but in terms of the procedure, if they indicated that they want to come and make a presentation before the committee, we must allow that opportunity for them to come and present.
Okay.
Thank you.
Now I understand.
Thank
So
you,
these ones that have applied to come to do the oral
Yes.
presentation, it's those ones that you mentioned. So it's fine. I think the honorable members are able to understand the process of what's going to happen. And Yoli, is there anything that over and above what we have presented to just caution us and say anything before the deliberations by the members? Which I think there's nothing that we can do. It's the presentation that Lindy is saying that we advertise it to happen like that. Yoli?
Yes, Chair, maybe just to say, maybe, I'm not quite sure, the public hearings are next week. Maybe just members, maybe just remind themselves when looking at my presentation and the reports and have the bill, just to see what is proposed in the bill actually, and what are now the inputs that the stakeholders made, so that you can follow, because right now I'm just presenting what they submitted without going to the proposed bill and see and cross-reference in what is being proposed in the bill. So if members maybe can give themselves some time to look at the bill, to look at the proposals and familiarize themselves, just so that they can be able to follow when we have public hearings next week and when the department comes to make responses, Chair. I just maybe give that advice.
Okay, Yoli, I hear you. And also members are able to hear you clearly. And then let me also give them the chance to say Bridget, Honorable Bridget, and yeah, so far so good. It's Honorable Bridget. Let me give over to you, Honorable Bridget.
Thank you, Chairperson. I omitted earlier to wish the birthday girl a happy birthday and a blessed one. Chairperson, I understand clearly what has been presented to us, not the content. The content is confusing me, but I understand how I understand the process as has been outlined by both the secretary and our content advisor. The one was jotting down questions. So I just need to understand even more clearer. The questions that we were jotting down are going to have to wait for when the organizations are here or when the department responds. I don't know if I'm making sense, Chair, with my question, because obviously one has forgotten how things work, and one was scribbling down questions. So do we wait until the organizations come or when the department responds? Because obviously these questions are straddling between the organizations and the department, in my case at least. So I would just like to be clarified on that. Thank you so much, Chairperson.
Thank you, Honorable Bridget. Honorable Letty.
Good morning, Chair. Compliments on the new year.
Morning.
Yeah, and happy birthday to the birthday girl. I think I'm mainly covered by the question of Honorable Bridget, because to me, I think it don't make sense that because we have jot down our questions as honorable or our inputs that we want to give. It makes sense to me to what Yoli was proposed, that we must wait till the other parties also come and present, or other people come and present, and then we can pose the questions most obviously to the department, or whether it's the legal law people that will advise us on that. That is my submission.
Okay, thank you. Thank you, Honorable Leti. I think we are on the same boat in terms of really, I'm asking myself, what is it that we're going to do right now that there are still other stakeholders that are still to present? Yeah, maybe let me check the hands. Honorable Kate?
Thank you, Chairperson, and happy belated birthday. And thank you, honorable members. Chair, I think I'm sharing the same sentiment with the two honorable members, because I was asking myself as to what is it that you are going to ask. Meanwhile, there are still some presentation that we are going to receive. So I think the only way to go is to wait for the next presentation, and also to go and familiarize ourselves with the bill as Yoli have stated. Then we'll take it from there. But for now, because even if you can question some of the things, if the presentation still is going to talk about the issues that we'll be raising today, it's like we'll be going back and forth. Thank you so much, Chair.
Thank you, birthday. Yeah. Then, yeah, I think we are all in the same boat. Can I also give Honorable Dikha?
No, thank you very much. A very good morning to you, Chairperson, and all honorable members, and everybody who's in the platform, and greetings also for the new year, and all of the best to everyone for the year ahead, and the compliments of the season. Chairperson, I just want to indicate also that I agree with the honorable members in terms of the approach, in terms of clarity seeking, and all of that, in terms of the process as it has been presented by the content advisor. And by so doing, I also want to join my colleagues to wish Mom Kate a happy birthday, and then all of the best for the new year, and let the Almighty bless you, and all of the best for your future endeavors, Mom Kate. And then, Chairperson, I just want to make a few observations, and then also with regard to the process that unfolded towards the process of the Older Persons Amendment Bill. And then one is actually encouraged by the fact that there was an overwhelming support for the bill during the public hearings. I mean, this is what happened, throughout the different provinces that we went to. And then also there was a high turnover of participants and overwhelming support for the bill, which actually affirms that our public is concerned and takes seriously the protection and well-being of the older persons. And then the submissions raised a range of critical issues, such as the costing, the creation of a favorable environment for older persons when accessing services, and then also the measures to prevent the abuse and clarification of definitions, as well as the clauses. And then I also want to indicate that the department must also be commended, Honorable Chairperson, for its continued effort in ensuring that the older persons are integrated into the society, and that their rights and value in society are recognized, and then also respected and also protected to a large extent. And then the responses from the department are also welcomed, and they actually deal with the matters which are actually raised and which were a matter of concern when we went to the public hearings. And then some of the issues were not adequately addressed by the department, such as, for an example, the placement of the older persons and determining the judgment, and also the agency of older persons in instances where they have to be removed without a court order, which was also a main issue which happened, and which was amongst other issues which was raised or highlighted by some of the inputs in the public hearings. And then also, I also feel that the department could have actually maybe clarified as as part of their response to the public hearings on the caregiver and non-registered persons taking care of older persons. So, Honorable Chairperson, from my side, those are the observations that I just wanted to raise in the meeting. But of course, maybe moving forward, we'll get an opportunity to raise clarity-seeking questions when we move forward with the process. Thank you very much, Honorable Chairperson. That's my submission. Thanks.
Thank you, Honorable Tirang. Even myself, I'm listening to the submissions in terms of this thing of the High Court or the court proceedings when we need a consent to place an older person in the center, where they are arguing that we need to have a clear and consent and agreement in terms of an older person before we, that thing, we were doing exactly that. But because that those that are vulnerable in other areas, sometimes they are really unable even to speak for themselves. And now we are saying, let's not wait for the court judgment or court proceedings. Let us, as communities and also as social worker, recommend. But they are submitting that let's have more whatever consent and also agreement with the particular person. But we can't really discuss it now. Maybe let's also, as honorable members has already said, wait for that presentation submission, that is orally submission from the stakeholders that have applied to do it next week. And I don't see. Oh, your hand is up. Okay.
Chairperson, you know what? I want to greet each and everyone this morning. I want to say compliments of the new year and happy birthday to all the ones that had birthday in January and February. Chairperson, member stock always speak last. My hand was up before member stock.
Is it?
He's always closing everything.
Doesn't show.
So now you're giving me his space now. Yeah.
Okay.
But I also want to say, Chairperson, this is a very important document that we are sitting with, because every day in our communities we are having grandparents, old people that is being abused by their own grandchildren. And even though we say you can go to the police and these people must be protected, these people are not being protected and they can't even speak for themselves because they are being abused. So this thing, we need to solve this thing as soon as possible, our Chairperson. Let's wait for the next one and see the stakeholders are going to come together and how we're going to do this thing, because this thing is a matter of urgency, Chairperson. The same with our children, the amendment bill. We need to sort this out because time is not on our side. And we know this might be our last few months in this portfolio. So I also want to say that let's get this thing over and done with, because this is the most important one, is the older person's bill. Thank you so much, Chairperson. Sorry, member stock, no, I didn't mean to take your position, your space, but it was the Chairperson's fault, no?
Okay, thank you very much. And also your gadget, don't show me that your hand is up. I'm sorry for that. I don't know what has happened, because I am able to see when a person raise up her hand or his hand. Okay, no problem. You are not taking over to anyone. You are right. That's your right to express what you think. But I think we are talking the same thing. Thank you ever so much for that. And then I don't see Yoli. Is it your?
It's me first, Chair, and Yoli.
Okay. Before Yoli, if over Honorable Mangani.
No. Thank you, Chair. I was just saying maybe we have delayed to give the report of the journey that we took to Canada, because some of the thing I think it might be helping us, some of the issue that we have learned. So we must compare it with whatever that the NGOs and people who have been doing the submission try to make. Why I'm saying this is just as South Africa, we have maybe delay or not think about the elderly because there were not many our elderly. So it's growing, but we didn't invest, us as elderly people. We didn't, they didn't work. So the comparison for Canada and us in South Africa, it might be difficult. So I was just saying it loud. Thank you, Chair.
Okay, thank you, Honorable Mangani. Yeah, you are right, because comparison is very critical on this. Can I check who else is hand is up?
Lindiwe and Yoli, Chair.
Huh?
It's me and Yoli, Lindiwe and Yoli, Chair.
Okay.
Chair.
Carry on, Lindy.
Chair, it's me. Am I audible, Chair?
Mm-hmm. Yes, you are.
Okay. Chair, I just want to quickly give a procedural advice. Chair, the proposals that are raised by members are on point. That the questions, the clarity questions that members have, they need to speak to the organization next week, and also not to make commitment that we are going to effect such proposal, because the critical process is for the department to come before the committee with all the suggestions from various stakeholders to say we agree with this one because it's implementable, this one is challenging, and so forth, for the committee in order for it to make a decision whether they take this proposal or not. And Chair, also the program will also outline the process going forward in terms of processing this piece of legislation, because there are cross-cutting issues. There are other departments that needs to appear before this committee to respond on issues raised during the public hearings. So for now, and also in that process, members would ask clarity-seeking questions as to how certain things that they propose should be implemented. And thereof, on the 6th of March, the department will come before the committee to respond to each and every submission received during the process of advertisement. And so as the committee to apply its mind to effect such proposal, Chair. And also the legal people will also be here to guide the committee in this process. So I just wanted to say the department is here to listen to all these submissions, and opportunity will be given to them to respond to all the submissions, whether it's doable, if not doable, what are the reasons. So like any other legislation that we've done that. I think it's on the 6th or the 8th of March, they will come before the committee to make a presentation of all responses that were received by this committee. Thank you very much.
Thank you, Lindsay. Last word, Yoli.
No, Chairperson, I'm covered. Yes, just Lindy has addressed what I wanted to say, and just safe to say the members may just, I'm just reminding them, it's almost the same procedure that we followed with the Children's Amendment Bill. If you remember, we had the presentation of the summaries so that you can prepare in members for the engagements that are coming with the stakeholders, so we know what issues they raised. And if Mama Sang has some questions jotted down, at least now she's better prepared for next week engagements with the stakeholders. And thereafter, if you remember, members, the department had made a matrix, a nice matrix. Maybe by that stage, maybe clarity will better understand what was raised by the stakeholders. Mama Sango said she's a bit confused by the content. I agree, because there was a lot of terminologies that maybe we're not familiar with as a committee, but I think when the department comes to address those things, maybe to become a bit clearer. So going back to what we said, Chairperson, I must give advice. Please, members, familiarize yourself with the bill, what is being proposed, so that we can understand what these submissions are about, and then we can then engage with the stakeholders and deliberate later on. With regard to Honorable Manganya's point is an important one, especially in the report, the last section of the report, it covered the lessons learned and recommendations for us, South Africa. Some of the issues that we learned about in Canada were raised during our public hearings in provinces, for example, where older persons were calling for a platform for them to be able to raise their issues, like a national platform or office in the office of, or a desk in the office of the premier or whatever. That what we learned, that in Canada they have structures like those. Those issues, that's what some members of the public had also raised. So you can also refer back to that report, Chairperson, especially the last section that deals with the lessons learned and recommendations. So members have all these tools for them then to prepare for the engagements coming before coming the next week's, Chairperson. Thank you.
Okay, thank you very much, Yoli. I think we are talking the same thing, all of us, and we agree in terms of the processes and procedure. Let's let me check whether is there any other end. Seemingly there's none. And now, if it is the case, let us not waste time, rather to adjourn the meeting and see the next week's meeting, and then that one of March, so that at the end of the day we finalize this. Because
Chair,
we don't have time. Hello.
Chair, there's another item which is, I think it's going to be short. The first term program.
Okay. Yes. Yeah. Thank you very much for reminding me. Otherwise, I have opened up the agenda, which we have adopted. Now, thank you very much for this one. And I think we have summarized it the way that I think it's the correct one. But let's continue and go to the next item, or the last item, which is the program. This thing of this program, honorable members, we definitely have to be very flexible on it. Now that if you look at the program, you will get Fridays, especially on the first. Is it first? What's the date? But there is the 20th. What is this date? 23rd.
23rd June.
Yeah, 23rd, which I know for the fact that there are SOPAs in other provinces, which we have to also attend. But let's maybe see how far we go with these dates that have been proposed. And if it needs to be postponed for another date, and be flexible. I also see that Friday, 8th March, and also there is another Friday that I know they are supposed to be meeting. I know for a fact that Fridays, it's some of our honorable members are traveling from work to homes, and they are also flying. But we cannot say we are not going to utilize Fridays, and we will try and be very short so as to allow those that are traveling Fridays. I had to also agree with Lindiwe to also utilize Friday, which we know that they are very, very tricky and also full up of traveling. So far, so good. It's still Zoom meetings or virtual meetings. It's not physical meetings, but I know the chief whip of the majority party is saying that we must also try those that are critical and have it physical in the rooms or in the boardrooms that are available in Parliament. So, Lindy.
Hello, Chair. Chair?
Okay. Yes.
On the 23rd of February, I've got the meeting the whole day of ethics.
Yeah,
Yes.
that's exactly what I meant when I said that other honorable members might be engaged on other areas on that day. Then the only thing that you have to, your secretary must just forward the apologies on those particular days. Because if I say, okay, because you've got ethics, let's not continue with this meeting, it will also impact on other honorable members that might not be. Those that might not make it, and if the quorum assists us, I persuade you to continue with the meetings. Then we will see our way out. I know for a fact, even myself, I've got Fridays that I might not make it, but I can't say the meetings. As you've seen it, we don't have any more time except the dates that have been proposed here. Thank you very much.
You didn't hear me properly. You are so fortunate you've got the secretary. So we don't have. Since the parliament was banned, we don't have any. Some are so fortunate. So I don't have.
Yeah, thank you very much, Jane. What you used to do, just put your apology in the group or Lindiwe's chat, and then we will know that you have apologized. It's fine. We hear you, and we really appreciate that you have done it upfront on time. It doesn't mean that you have to have a secretary. If you don't have it, just write an SMS so that Lindy don't forget to forward your apology. Thank you very much. I'm sorry for you not having the secretary, and I know for a fact that we were sharing secretaries which are still not assist us as members. Thanks ever so much. Here is the program, honorable members, and what else do we say on it? I don't even want to waste time by saying it must be read, but Lindy, if there is anything that you would like to highlight on it, otherwise it is in front of us. 14 February is today. We are having this. Lindy, continue
Chair?
from the first. Yes.
Chair, 21st is the virtual hearings with 5 organizations. Little Abantu, Professor Malebe from UWC, Posatu and Mr. Randa Meyer, Service Center for the Aged and the Timeless Care Seniors. Only those 5 organizations indicated. Chair will also adopt the report on provincial public hearings. Remember, we went around the country to 9 provinces. So there is a report that came out of that process. The 23rd, Chair, is the first Friday. Will receive a briefing from the Department of Health as well as from the Department of Police to respond on issues emanated during the public hearing sessions, Chair. And then the 28th of February, we will receive a presentation, Chair, from SALGA as well as Human Settlements to respond on issues raised during the public hearings, Chair. The 6th of March will receive also one of the departments that they need to respond to, Justice Chair and Basic Education. They will come before us and respond. On the 8th of March, the DSD will also respond. After all the other departments have responded to all these issues, the 8th of March, DSD will respond. Chair, the 13th of March, and then after we've received the responses, and then we will adopt and consider the MOD, whether the bill is desirable or not. Also, at the same time, Chair, because that process is very short, we will receive a presentation on the financial and non-financial performance, Chair, for the second term, which is July to September from DSD. And then the 20th of March, Chair, will deliberate and consider of proposed inputs on the bill, which is we will go towards the compilation of the A list. And then the Friday, the 27th March, Chair, we will get and the A list, the legal advisor will prepare the A list, and then the committee will consider and adopt the A list. And because it's a very short process, we'll also invite DSD to brief us on their third financial and non-financial performance, Chair, October to December. And then the last Friday, Chair, we will consider the B version of the bill and the committee report, Chair. Also, we do have the legacy report that this committee must adopt and the annual report, Chair. The reason why, Chair, we as indicated to you, we fit in these Fridays. My manager encouraged that all the processes, legislation must be completed in the first term, which is January till March. So we are under pressure, Chair, to make sure that by March, the entire legislation is finalized for further process. Thank you very much, Chair. It's only 3 Fridays, which is the 23rd of February, the 8th of March, and 29th of March that they must set aside to attend this meeting. Thank you very much, Chair.
Thank you very much, Lindy. There is the program, honorable members. Can I get anyone who adopts it and a seconder?
I move for the adoption, Chair, of the program. Thank you.
Thank you, birthday woman. And any seconder to that as proposed. Otherwise, we are aware that some honorable members might have the apologies. We've heard that we are rushing because it's an end of the term within 4 months' time. Any seconder?
Chairperson, this is Bridget. I'd like to second the adoption of the program with one objection that one of the Fridays is my birthday, so maybe the chair should postpone the meeting.
We still have to eat these cakes. Which is yours?
The 23rd of February. I suggest the chairperson postpones that meeting. But that's on a lighter note, Chair. I would like to propose the adoption of the program. Thanks.
Thank you. Thank you very much. I think you'll bring a cake, even if it's on Zoom. You'll put it on Zoom so that we can share that cake through the Zoom. Thank you very much.
Thanks, Chair.
Thank you very much.
So we share a month, Bridget. Oh.
Yeah. Aquarius.
And you, Chairperson, no,
yes.
We deserve to have a party as this collective.
Okay, it's fine. We'll do it on the 23rd. Thank you very much, honorable members. The program has been adopted and also seconded. Any other item, Lindy?
No, Chair. May adjourn.
Okay, we're done. Thank you very much. Can you see that, Honorable Bridget, we have managed to keep the time and we are done before that 12 o'clock of yours. Thanks ever so much for all those honorable members that managed to have to come to the meeting. I know for a fact that Umatasa it's so hectic, but we are trying our level best to honor our portfolio committee. Thanks ever so much. Love you all, honorable members. Take care. Prepare for the buses and to take off to Parliament. Good luck for the day. Thank you. The meeting has adjourned.
Thank you, Chairperson.
Thanks.
Thank you.
Thank you, Dango.
Thank you, Chair.
Thank you. Thank you.
Thank you, Chair.
Thank you, Chair.
Thank you. Thank you.
I will end the meeting for everyone if we are done, members. The greeting.
Yes.
Okay.
Thank you very much.
Thanks.